My name is Mukesh Bhutani, and I'm from Taxand, India. I'm moderating this session. The session is all about how do you manage tax litigation in the context of international tax cooperation. Let me start first with India. Some of the emerging trends clearly suggest a long drawn tax litigation. India has been in news for this now for some time. Past attempts that have been made by the Indian tax policymakers on having a meaningful alternate dispute resolution mechanism, in my view, has failed. Also seen surge in directional tax policy changes by way of retrospective amendments. The famous Vodafone case. Origin lies in India. This is a case on which the tax authorities went and decided on what happens in the context of taxability of offshore transfer of assets where the underlying assets lie in India. However, there has been a move with respect to constituting of special courts to be able to deal with tax cases on a priority basis. Finally, what is important for taxpayers is not that there is litigation in India, but whilst you fight the litigation battle, what happens to tax demands that have been raised by the tax authorities?
But it's true that now if you talk to any Spanish people, not only to tax practitioners, you will find that they are very sensitive about taxes. And probably the newspapers and the media have something to do with this. And also, because I'm sure that you're familiar with the Spanish football league and with the Spanish football clubs. Unfortunately, there have been news on tax matters concerning some very famous football players, like Leo Messi and Neymar, both of them playing for Barcelona. I don't support Barcelona, I support Real Madrid, but that has nothing to do with the tax assessments. No, but these days in Spain is an excellent time to reach a settlement. I many times tell my clients, even if it goes against the fee generation for my firm, is the best litigation you have at court is the one that you don't have. So if you can avoid it, just try to avoid it. And now it's the climate in Spain is good for reaching settlement with the tax authorities. And finally, just a quick reference to our neighbors in Portugal. I believe that they have been pioneers in setting out an arbitration procedure that have been applied directly by the taxpayers. And what I hear from my colleagues of our Lisbon office is that this is being quite successful. It has been in place for something longer than 2 years, and they have made more than 200 decisions on arbitration. So probably arbitration is a solution to look at for other countries.
When we looked at this panel, the idea was to give a flavor of the tax landscape in various countries, but the features, if you see in the landscape, these features really across to many jurisdictions beyond the 4 jurisdictions that are represented on this panel. Craig.
I want to start by saying it's good to see the number of people in the room for a litigation session. Louise touched on it. Clients hate being involved in tax litigation. Tim actually said he thought we might have no one turn up, so his expectations have been exceeded. I say that from the perspective of generally once you get into litigation in Australia, it tends to dig in, it becomes protracted and very long. And my message that I'm starting with is you need to pick your battles very carefully these days. The tax office in Australia is having a lot more success. We'll see that when we look at their success rate a little bit later. But they're becoming more sophisticated in picking their cases. They are becoming better at picking which cases to litigate through to the courts and not pursuing the others or settling them early. By the same token, you need to be very careful about which issues you wish to litigate, and once you make that decision, you have to be all in.
And the courts are imposing higher and higher cost awards as part of the effort to push people to settle, in particular the CRA. There's a perception within the Canadian tax community, whether it's accurate or not is another question, but there's a perception that the CRA, feeling like they have unlimited resources, can just keep fighting and fighting. I'm not sure that that's fair. having worked inside government, I know that government does not have unlimited resources, and they're aware that they don't have unlimited resources, but there is that perception, and certainly the tax court is trying to put more pressure on parties to reach settlements.
So, what's our overall guidance from a 2020 standpoint? Litigation is a reality. It's a reality partly because government actions will force multinationals to manage their litigation, and it is going to become an even more complex exercise in the post-BEPS era when non-OECD members assert themselves in the strict source-based rules, and OECD members apply the cocktail of source-based and resident-based rules. That's our overall take is first a tax litigation mitigation strategy by making sure that your documentation is in place. It's robust enough to be able to respond to the growing needs of the revenue in the context of post-BEPS era.